first one?
You are now live.
49. Tuesday, March 22nd. Senate Finance, and we're taking up for first time to be walk through on H489. 6 senators present. Jennifer Carby is the first witness.
Good afternoon. Jennifer Carby from the Office of Legislative Counsel. Oh, you can't hear me?
Now we can.
Okay, great. So Jennifer Carby, Office of Legislative Counsel. We are looking at H489. Do you want me to put that up on your screen, or are you looking at it in hard copy?
We have paper copies, and
Great.
a couple senators are on their own devices.
Okay, great. So I will give you kind of a high level overview. It's the original bill is from DFR, and so I think they're going to speak in more detail to many of the provisions, but some were added or amended in the House. So this bill is an act relating to miscellaneous provisions affecting health insurance regulation, and it starts out in Title 8 on the insurance title. And the first section is dealing with compliance with federal law, and it is adding in references to the No Surprises Act, which you might have heard about, passed, I think, last year. And I know Sebastian has a good overview of it if the committee is interested. I'm not sure what you're looking at with it, but this committee may remember because I think two or so years ago, you were looking at surprise medical bills and how to reduce the instance of people getting settled with surprise medical bills after receiving healthcare services. So, so this is putting in a requirement that health insurers, various types of health insurers, and healthcare providers comply with the requirements of the Federal No Surprises Act. It directs the Commissioner of DFR to enforce the requirements as they apply to various health insurance insurers and healthcare providers to the extent permitted under federal law under the Commissioner's authority under Title 8. It also allows the Commissioner to refer cases of non-compliance to the U.S. Department of Health and Human Services because DFR has a collaborative enforcement agreement with them, or to the Office of Vermont's Attorney General. Section 2 directs DFR in collaboration with the Health Department and DVHA and professional organizations representing healthcare providers to inform healthcare providers of their responsibilities under the No Surprises Act.
Senator Srotkin has a question.
Why do we need these two sections?
I'm sorry?
Why do we need these two sections? There's no, you need a state law to tell the state to follow federal law?
No, but as far as DFR enforcing the requirements of it, it seemed important to specify that DFR, the Commissioner of DFR, has that authority. There is, and DFR can tell you more about it, but there is a collaborative enforcement requirement between the state and the federal government. So
The next witness is from
in
DFR.
federal, right. So putting this in statute ties it into Vermont, makes it a state requirement as well, which allows DFR to enforce. Section 2 is not codified. It's just it's just a provision of session law. There had been concern about whether providers and insurers were aware of their responsibilities under the No Surprises Act. So this would require outreach to them. Section 3 makes a number of, and throughout this, you'll see there's a lot of cleanup changes, either getting rid of legalese or moving away from using gendered pronouns. So this section 3 is on group insurance policies, group health insurance, and there are some provisions in here that DFR requested that clarify, or in some cases make changes to the provisions of law that apply to health insurance plans or policies issued to associations and trusts. So DFR can speak in more detail about what's in this section. Section 4 relates to an existing law on independent external review of healthcare service decisions. This is when somebody can ask for an independent external review if an insurer makes an adverse decision that affects them under a health insurance plan. And there are reasons that the independent review would be available, including the decision involves an adverse determination related to surprise medical billing, including whether something was subject to an adverse determination is something to which the No Surprises Act applies. That doesn't apply to all healthcare. It applies to emergency care and other medically necessary care. Section 5 eliminates.
Senator Pearson has a question.
Yes.
Jen, as you will recall, because you've drafted various proposals for me over the years, I have been among many trying to get at this No Surprises Act and on, you know, no surprise billing and all of this. And it's, in my experience, in Montpelier, been elusive, even as the legislature enacts language that is trying to actually accomplish some of what we're talking about. In your opinion, is the federal legislation got teeth? I mean, is it going to work? Is it, I mean, I guess I'm just looking for your opinion. The health industry has been one of the more creative at getting around very straightforward things like send out bills that people can understand. And my wife and I, we just let them pile up until the final bill arrives. You know, it's just insane. So in your opinion, is the No Surprises Act going to make a difference?
I think it should, as far as the surprise bills, you know, bills when somebody wasn't aware that a provider at an in-network facility, a specific provider was actually not in the plan, even though the facility itself is in the plan, or receiving emergency services out of network when there isn't an opportunity to make decisions about choosing a provider that's in network. I think having consistent laws on this that will be known and enforced across the country should provide hopefully some benefit, but I don't think it doesn't apply to all bills, and it doesn't apply to you know, things like waiting. You know, you have, as you mentioned, have sponsored bills that, for example, would not have a bill come to a hospital bill or medical bill come to the patient until all of the back and forth between the provider and the insurer was done, so the patient would know what they're actually being required to pay and not just an earlier pre-insurance bill. It doesn't address situations like that. So it doesn't go as far as some of the things that you've been interested in, but it does definitely take a step further than what has been in place in the past.
Thank you.
All right. Section 5 of the bill removes a reference to the Department of Financial Regulation. This is in the Green Mountain Care Board bill back statute. There's a requirement that the Green Mountain Care Board report annually on its use of the bill back law, how much it actually billed, how much it could have billed back under that law. This would take DFR out because DFR is, as I understand it, no longer part of the bill back process. They had been, bill back used to be in BISHCA before there was a Green Mountain Care Board. And then there was some shared authority, but it does not apply to, at least this particular part of it does not apply to DFR anymore. Section 6 relates to some language that this committee, or many of you on this committee, may remember from a few years ago. This is entities that administer one or more HRAs, HSAs, FSAs, or similar tax advantage accounts. And the law that you passed directed DFR to adopt rules for licensing and regulating them. And it specified that the rules needed to include, and it said, annual licensure or registration filing requirements. This would take out the annual requirement. I believe DFR has found it more feasible to administer on a different timeline than annual. Section 7 is a provision in the advanced directive statutes. So advanced directives being documents that people can use to appoint a healthcare agent to make decisions for them if they cannot make their own, and also express their end of life wishes or other wishes for treatment if they are not able to speak for themselves. This would add to the definition of a healthcare decision for purposes of the advanced directive statutes, consent to receiving out-of-network services. So that is something that can be under the No Surprises Act, somebody can knowingly consent to receiving out-of-network services. And so this would allow an agent making healthcare decisions for a principal to also consent or withdraw consent or refuse consent to out-of-network services on the principal's behalf. Section 8 was added in the House. This did not come, at least originally, from DFR. This would create an insurance parity in residential care for children and youth working group to increase access to appropriate residential treatment for children and youth enrolled in commercial health insurance. It appoints to the working group representatives from the Departments of Mental Health, Department for Children and Families, DFR, Agency of Education, Department of Vermont Health Access, representatives from residential treatment programs, including 2 different types selected by Department of Mental Health in consultation with Department for Children and Families, representatives from commercial health insurance carriers selected by DFR, and someone from the Office of the Healthcare Advocate. It directs the working group to examine the barriers that make it difficult for children and youth to access medically necessary residential treatment, identify the reasons that Vermont residential treatment programs are resistant to becoming approved providers for private insurance, propose solutions to overcome those barriers and reasons identified under subdivisions 1 and 2, including the possibility of creating a common set of quality and utilization management criteria and processes for private insurance and Medicaid-funded residential treatment, and looking at solutions to streamline funding options for state-placed private pay students by considering some provisions from the education laws as they relate to state-placed students for special education purposes. Gives the working group the administrative, technical, and legal assistance of DFR, and would have a report coming to certain committees by December 15th, 2022. Does not have it coming, at least at the moment, to this committee, but we can add you if you'd like. Talks about who calls the first meeting, and the working group would cease to exist on December 15th. And I saw a hand, and then I'll do the.
Thank you. This working group, I mean, I think I can guess at what the problem it's trying to solve, but is it that kids who are placed in mental health care facilities or drug treatment facilities, insurance doesn't reimburse that care, or?
It's my understanding that there seems to be some perhaps lack of cooperation between the payers and providers in a way that would make the provision of services and availability of services easier for families on private insurance.
Okay, so public, like Medicaid pays for it, but private insurance does not?
Medicaid pays for it. You may need to ask other witnesses about private insurance. I don't recall that I wasn't present, let's say, for a lot of testimony. I'm not sure if it occurred or not on this topic.
Okay.
It does seem to be an issue, and I believe it's an issue known to DFR, so they may be able to speak to it as well.
Okay, great, thank you.
All right, finally, the effective dates. The act would take effect on July 1st, except that working group would take effect on passage.
Ms. Rudkin.
Is there a number of meetings set forth in the bill?
For the working group?
Yeah.
Don't believe so. There's no per diems in it, so it did not limit the number of meetings. It just requires that the commissioner of finance or someone from DFR would be the chair and call the first meeting by a date certain, and the working group would cease to exist 6 months later.
More questions for Jen? Thank you.
Sure.
Next witness is Emily Brown, Director of Insurance Regulation, Department of Financial Regulation. Welcome.
Thank you. My colleague Sebastian Arduengo and I are actually, excuse me, going to tag team this bill. So we'll kind of take it section by section, and each of us will speak to the different parts of the bill. And I think if it's okay with the committee, Sebastian will be starting it off.
Yes, hi, Sebastian Arduengo for the Department of Financial Regulation. So I think it might be most time effective to just try and address some of the points that you all made during Jen's walkthrough. So with respect to section 1, as Jen said, the purpose of giving or requiring insurers and providers to comply with federal law is to give the department specific enforcement authority under Title VIII. And the reason that's important in this context is that the No Surprises Act has sort of a novel enforcement structure where, even though it's a federal law, the states will be the primary enforcers, given the role of the states in regulating health insurance. So we wanted to have that specific enforcement authority in Title VIII, and to have that reference the collaborative enforcement agreement that we're going to have with the federal government. With respect to section 2, that was a provision that was added by the House Committee on Healthcare. And if and when this bill passes, we're going to start working with our stakeholders, both within the state and without, to develop educational materials for providers and insurers to let them know what their obligations are under the No Surprises Act. As to the No Surprises Act, as Jen also mentioned, I gave a presentation to the House Committee on Healthcare about that legislation and everything that it does. It's probably outside the scope of this testimony, but if the committee is interested, I'd be happy to give that presentation to you.
I'm sorry. So I'm sorry to interrupt you. The presentation is basically that the presentation that you would give to insurance providers, the educational presentation. Is that what you meant?
No, I meant the presentation that I gave to House Healthcare about the No Surprises Act and how it works and what it does.
Oh yeah, that would be interesting. Okay, thank you.
So section 3 is a change to our group insurance statute. And I'll turn it over to Emily Brown to go through what this change is.
Great, thanks, Sebastian. Emily Brown, Department of Financial Regulation. So as Jen mentioned, a lot of the changes in section 3 are cleanup. But what we were trying to do with these changes is better align our current group health insurance statute with the NAIC, and that's the National Association of Insurance Commissioner Model Law. We have received a lot of, I shouldn't say a lot, we've received a few association health plan filings, as well as several trust filings. And upon review of those filings, we realized that the statute that we currently have and the language wasn't very clear as to what requirements we were applying. So we thought it would be a good time to clarify the statute. And we look towards the NEIC, which provides model law for all states. The association changes, which you'll see under subsection 2A, are really just clarifying what requirements associations are required to comply with to form under state law as well as federal law. It really goes to the fact that if you want to form an association health plan, it's important that the employers are controlling the plan rather than health insurers. We did have one suggested addition to this language, which we realized was important after it went through the House, and that's on page 5, at least, of the bill I'm looking at, under, I'm sorry, I think it's under 2A Romanet 2I, and it speaks to the association or association shall not be controlled by an insurer. We'd also like to add their language that says by an insurer or producer, or I think the language would be insurer, producer, or broker. And this clarification would also not allow association health plans to be controlled not only by insurers, which is currently in our statute, but then also clarify that producers and brokers also shall not be able to control the association health plan. The control shall solely lie with the employers who are members of the association.
Senator Hardy.
Yeah, Emily, I'm sorry, I missed, there are lots of little I's in here.
I know, I'm sorry.
Which one, I'm sorry, I missed what page you said.
Page 5, first line down.
Page 5, the little I.
Yes, exactly. Let's see, I'm 1, 2, 3, 4. I'm on the 4th line, at least in my document. Let me see what the actual, I don't have the as passed version in front of me, but it reads the association or association shall not be controlled by an insurer as evidenced by the operation of the association or associations.
Wow, that is a really confusing sentence.
Yeah, it is. It is confusing, but I think what it's essentially saying is that the association can't be controlled by the insurer, and this is important because what has happened in the past is that health insurance companies have tried to form associations essentially for commercial gain. And really the goal of an association health plan is that it should be formed for the purpose, for a purpose other than obtaining insurance. So that's why it's important that it's the employers that decide to get together and form an association rather than an insurance company coming, or a producer or broker coming to the employers and saying, hey, you should form an association health plan. It really needs to be formed and for purposes other than obtaining insurance and for a legitimate business purpose.
Okay, and now a follow-up question. I thought association health plans were no longer okay. Didn't federal law get rid of them?
Yes, you're exactly right. There was a law. So it's just to back up, to give you some historical context, association health plans have really been in existence since ERISA, which is the federal law governing employer-sponsored health insurance. Association health plans have been in existence since then. What the law you're referring to was an expansion of ERISA and the ability of employers to get together to form association health plans, and that was, I believe, in 2018. And what it really did is allowed to be kind of informal, allowed a group of any employer. You wouldn't even have to have a common business interest. You could be a restaurant down the street and a body shop, and you could get together under that expansion and form an association. But that rule, that expansion was actually overturned and repealed, that rule. So that is no longer in existence, but there still is this narrow ability for employers to get together as long as they have a common nexus or commonality of interest. They can get together still and create an association health plan to purchase insurance. And an example I can give, we actually have one fully insured association currently in our state, and that's VEDA, which is the Vermont Auto Dealers Association, which has actually been around for quite a while. And because it's made up of all the employers who are in the association have a common business interest, the purpose of the association is not for purchasing insurance. They were able to form an association under the stricter guidelines that exist at the federal level as well as at the state level.
Okay, so this is just cleaning up language for a very narrow set of people. And did you say you wanted this one in the current version of the bill? You're recommending an additional change?
Yes, I'm recommending, in addition to not allowing the association to be controlled by an insurer, I also think we should add in producer or broker in there, because a lot of the times too, you could have a producer or broker who might operate in the same way that a health insurer would by kind of trying to get employers together to purchase insurance. So I think that would be a good addition and also make the language a little tighter.
Okay, great, thank you.
Yep.
Senator Brown.
Just a question, just going back a little bit to page 3, paragraph B, which is really existing language. Can you explain how that works for out-of-state employers? I see this provision of 25 certificate holders in Vermont. How does that work if you have less than 25? How does this work for ERISA employees, for example?
Yeah, so for ERISA employers generally, or if you have an ERISA plan, you are exempt from all state insurance regulation. It doesn't matter if you have under 25 or over 25. What we're really talking about here is fully insured plans, so those that you're purchasing from an insurance company. And the way that this works is that, let's say you work for an employer in Massachusetts, but you live in Vermont. If that employer has less than 25 employees in Vermont or covered lives in Vermont, that insurance company that the employer is purchasing from does not have to file their rates and forms, meaning their health insurance policy or their premiums, in Vermont. And what that essentially does is allowed a Vermont resident to be insured under that plan, but not have their health insurance policy approved by the state because it doesn't reach that 25 or more threshold. And this is really common. This threshold is common throughout many states. And what it does is it prevents, if you're issuing a policy to one person, it would be really burdensome for the insurance company. They would essentially have to issue a whole nother master policy for that one person. And that person might have, for instance, different benefits than the other employees in a different state. So what it does is it allows companies and insurance companies a little room wherein if they're below that threshold, they don't then have to have a completely separate policy issued in another state.
Well, if you have this out-of-state company, it would presumably, if it's covered under this particular paragraph, is not an ERISA plan. Is that
correct? Exactly. Yep. Correct.
Clear. What triggers becoming an ERISA plan as opposed to not?
So what triggers becoming an ERISA plan, and I'll speak to like the single employer plan because that's easier, I think, an easier concept. So if you're an employer and you are thinking about what health insurance plan you want to offer your employees, you essentially have two routes to go. One of those would be to purchase a fully insured plan, say from Blue Cross Blue Shield Vermont. And that means that you're paying a monthly premium and you're assuming none of the risk of the claims experience. So If you end up having an employee who has a serious health condition, you will still pay the same amount of premium no matter what medical event occurs in your employee population. To become an ERISA plan would mean that you're self-insuring. So that means that you, the employer, are taking on the risk of your employee group and essentially self-insuring those claims. There is a little, it is a little dynamic because you may have heard previously that when we came in and talked about stop loss insurance. So while an employer might be self-insuring, what they'll do is they'll buy a stop loss insurance policy, which essentially provides that excess policy. So once your claims hit a certain level, the stop loss policy will kick in and cover those excess claims over the certain amount. But essentially, if you are an ERISA plan, you are self-insuring your employee population. So that's the difference between those the jurisdiction in those two types of plans versus ERISA versus the fully insured. Any other questions before I move on?
No, not me.
Thank you.
Okay, great. So the next change that we added in section 3, I believe it is, or section 4, section 3 was having to do with trust. So over the past few years, the department was starting to see an influx in filings by trusts. And under the current language, a trust was allowed to purchase a group health insurance plan if the trust was established or adopted by, and then it reads 2 or more employers or labor unions, et cetera. But what we were realizing is, just as I mentioned in the previous association section, is by including that language or adopted, you're essentially allowing a third party to form a trust and then sell a health insurance policy or market a health insurance policy to an employer without any of those employers necessarily having any relationship besides purchasing insurance. So when we started to see this activity, we actually went and looked at the NEIC model and looked at other state language and realized that or adopted language was actually a Vermont specific addition. And we felt that because, number one, it wasn't aligning with the NEIC model, and also we were kind of viewing it as a loophole around our association statute, we're proposing here to get rid of that or adopted language to make sure it's clear that, again, the trust has to be formed and established by the employers, the labor unions, for the benefit of their employees. So it is a technical change, but an important one, and will also better align us with the NEIC model law. And any questions? I'm going to turn it over to Sebastian. Any more questions on the group health insurance changes? No? Okay, Sebastian?
Thanks, Emily. So section 4 has to do with grounds for external review. And Jen mentioned to you that external review is when a consumer can contest an adverse determination made by their health insurer. And under current law, there are 4 grounds for external review, including that the insurer made its determination on the basis of medical necessity. For instance, they said that the services at issue were not medically necessary, or that the services at issue were experimental or investigational, which are typically experimental or investigational services are typically excluded by health plans. This statute would add a 5th ground for external review, which would be that if your health insurer determines that a claim does not qualify for protection under the No Surprises Act, then members and consumers can contest that decision through an external reviewer, just as they can with other adverse benefit determinations. Any questions? Any questions about section 5? Hearing none, I will.
That's just taking DFR out of that because you don't do that stuff.
Exactly right.
The Green Mountain Care Board does.
That's right.
Okay.
Section 6, there is one thing that we wanted to add to Jen's testimony here. And the reason that we are requesting the removal of the word annual licensure or registration filing requirements is that in subsection D of this section, which is not quoted in this bill, there is a required $600 fee with a renewal every 3rd year following initial licensure. So we requested the word annual be removed to remove that inconsistency from the statute. Section 7, as Jen said, would give healthcare power of attorneys the authority to consent to out-of-network care. Any questions about that? Section 8. I think I'll start here by trying to describe the issues that were brought to our attention by the Department of Mental Health. Very broadly speaking, it is difficult to impossible for children with private insurance to access residential mental health treatment in Vermont. There are a handful of facilities in the state that provide that treatment, but none of them accept private insurance. And when we discussed with the Department of Mental Health, what we were advised was that the barriers have to do with the accreditation process that commercial insurers require. And that process is just too burdensome for these facilities that we have in Vermont because they're already sort of maxed out, especially now with COVID and with staffing shortages. Another issue that's blocking access for children with private insurance is that the Agency of Education does not pay for the educational component of care when a child is placed into a residential treatment program by the state, but is covered by private insurance. And this is something that the Agency of Education pays for Medicaid beneficiaries. At the same time, commercial insurance plans exclude coverage for education. So there's a big component of residential mental health treatment that wouldn't be covered even if these facilities were in network with private insurers. So the study group is being proposed by the department in conjunction with the Department of Mental Health to gather all of the stakeholders and see if we can develop a consensus on how to resolve the accreditation issues and get these providers in network with private insurers, and also how to address the issues with the education funding component of this care. And it's our hope that we can come back next year with a very short report and very detailed recommendations in terms of we need to change X statute and Y statute and require Z to sort of pave the way for children with private insurance to access these facilities in Vermont.
Interesting.
Senator Hardy, is this a catch-22 where you have to be approved by someone who's accredited to approve you, but those people who would be accredited to approve you don't get accredited because it's too complicated? Is that or too
Possibly,
expensive, or?
possibly. It's all, the whole difference between treatment and education is really interesting. I also think, Sebastian, you said you were gonna do a short but detailed report. Isn't that an oxymoron? I really can't wait to see that.
Yeah, my thinking about how this report would be structured is that it would be maybe 2 to 3 pages on background and maybe 2 pages of the specific proposed statutory fixes that we'd have to address the problems that we could all work out over the summer.
Okay, so you are such an optimist. I love it. 6-page report. If I'm still here, I can't wait to see that. But it does seem like a really important problem to solve because there are a lot of families that just can't access this care.
Yes.
Can I ask another question?
Senator Hardy.
Unless there are questions on this section, I have a question on a previous section for Sebastian.
Fire away.
Okay, so I think it's this right at the beginning of the bill. I think it's section 2, maybe, on provider outreach about the No Surprises Act. Is there any outreach being done to consumers or patients to let people know what the No Surprises Act so that they know when they've been surprised and what they should do about it?
Yes, so on these groups, we typically work with the Office of the Healthcare Advocate, and we would likely issue consumer notices on our own as the Department of Financial Regulation. So I think we could do more consumer outreach insofar as holding public forums where we could educate members of the public as to their rights under the No Surprises Act. And if the committee wanted to formalize that and add language to that effect, that the department wouldn't oppose it.
Okay, that's great. I think it would be helpful because I think a lot of times consumers don't know what their rights are and they don't know who to talk to if something bad has happened to them. So if you have suggested language for that, that would be great.
If I could just add to, the department is currently working on a healthcare access public-facing document, and I think we are planning on putting in information about the No Surprises Act So that's something we're hoping to get out in April. So there should be some consumer-facing information coming out soon on the No Surprises Act.
Okay, good. So maybe that's not necessary, but I just want to,
It doesn't hurt to add it.
yeah.
Yeah.
Okay, great, thanks.
Any other questions for the witnesses? Well, that wraps up this one. So we're scheduled to come, I guess, be on break until 2:30 unless any further questions. Thank you very much.
Thank you.
Thank you.
Faith, I'm gonna mute us.
Would you like to go off live stream?
Oh, going up.